Court, and more specifically, the role of the ICC Court over the last 100 years in promoting the rule of law. We're also going to reflect on some of the potential threats to the rule of law, and near at the end of the day, we're going to be making some predictions for the next 100 years. That's me. It was quite a daunting prospect to put together a programme grand enough for this occasion. I think you'll agree we've lined up for you some of the very best speakers, and I see Claudia Solomon right in the front row, who will be addressing you later. I also want to thank my co-organisers, my vice chairs. I see Guy, thank you very much, and Ian Quirk, who you will hear from later today, and the amazing team at ICC UK. So where is Nikki at the back, and Natalie, who always managed to pull off a miracle in putting the programme together, especially in the face of train strikes. And my last thank you goes to our host. So Matt, thank you very much for hosting us today, and I'm going to hand over to you now, and also to Chris Southworth, who will speak after Matt. Thank you very much. Hand over to Chris.
Thank you very much, Anya. I'll keep this very brief as well. Unfortunately, it seems EY-sponsored ICC events have a habit of producing train strikes the second year in a row, but I'm glad to see you all here. I'd just like to say what a privilege it is, firstly, to welcome you all here, and secondly, to collaborate with the ICC in sponsoring and hosting this event. We're really proud of that collaboration with the ICC, and it extends beyond arbitration and includes, amongst other things, having our former managing partner, Steve Varley, on the board of the ICC UK and collaborating in various other initiatives as well. Like the ICC, EY has a very long history, created as Ernst & Young back in 1989, but from a merger of two firms that trace their lineage all the way back to 1849. And today, just like the ICC, we're a truly global organisation employing close to 400,000 people in more than 150 countries around the world. A very small part of that, they're very much your gateway to those 400,000 people around the world, is my team, who focus on providing expert witness input in the context of disputes, with 37 of us here in the UK and also various others around the world, including my partner, Frederic El-Kaslassi, who joins us here today from Paris. Lawyers often say to me that the big four, of which, of course, EY is a part, rely a bit too much on brand and reputation, and maybe don't spend as much time engaging with the arbitration community. And this is very much part of our effort to counteract that preconception and engage with you all today. We're looking forward to doing that and learning from lots of interesting discussion and debate amongst the speakers and all of the audience today. In terms of engagement from the audience, I've been asked just to say we're ready to ask a question and contribute from the audience. Please just wait for a microphone as well. That's all from me. Thank you very much, and let's get on with the day.
Well, thanks very much, Matt and Anya. I'm Chris Southworth, Secretary General of the International Chamber of Commerce here in the UK. It's amazing to be here celebrating the centenary of the International Court of Arbitration. For us in the UK, that comes right off the back of having changed the law to modernise trade with the Electronic Trade Documents Act. That's upgrading law from 1882. We're a founding member of ICC way back in 1919 and of the court itself in 2023. So it feels like we're on a roll here. We've got lots of economic challenges and political challenges in the UK, but I think the ICC community can be really proud of the contribution we are making to that international agenda. So first of all, just a huge thank you to our sponsors, Matt and EY, for hosting us. We're always super grateful for those who are willing to sponsor these kind of events. Opus 2, Debevoise and Plimpton, the Wordley Partnership, Ancora, Fieldfisher, and of course, the ICC court here with Claudia. It's great to have you in London. We don't get that opportunity as much as perhaps we always want it. But I think, you know, the numbers that come out of the court speak for themselves. You know, it's 28,000, I think the 28,000, if that's a word, case. I mean, that's incredible. It's 280 billion plus in terms of dollars value of cases processed every year. It's the largest commercial arbitration court in the world. It's absolutely enormous. Now, lots of UK companies themselves aren't aware, surprisingly, of what's going on in the dispute scene. So there's always a big challenge to get the word out, down through those supply chains, through the corporates, out to SMEs with our partner organizations. And that's a really important role that we play within the ICC team, supporting all of you. But ultimately, this event and these types of events for us are quite straightforward. This is the opportunity to convene the real experts, the practitioners in this field, which is you. Our job is to help make that happen in order to help Claudia's team shape those global frameworks, lean in to make sure that arbitration, like all other rule books, is right at the cutting edge of modern trade, but also on a practical level to implement practical solutions like the arbitrator database. So we're promoting diversity in the field, helping those younger arbitrators come through and develop their careers, and of course, ultimately promoting international best practice, which is what this event is all about. So it's great to have you all here. We've got a fantastic lineup of speakers. I wish you all the best for the day ahead. I'll be around, the team will be around if you've got any questions. Thank you very much.
And as if by magic, we're already back on time. So it's my absolute privilege to introduce our morning keynote. This is a person who, as we say, really needs no introduction. So I will keep my words of introduction really short. After an illustrious career at the bar and other things, Lord Neuberger was appointed Master of the Rolls in 2009. In 2012, he became President of the United Kingdom's Supreme Court, a position he held until 2017. He presided over the Supreme Court during some of the most significant legal and constitutional decisions of our time. And I'm just going to quote one thing from Miller, because you will have seen the theme for today is promoting the rule of law. And in Miller, Lord Neuberger presided over 10 of his colleagues, only 3 of whom dissented. And the leading judgment with which I'm sure Lord Neuberger had care in every single word that was used included the following quote: "In the broadest sense, the role of the judiciary is to uphold and further the rule of law. More particularly, judges impartially identify and apply the law in every case brought before the courts." And you'll see that emphasis on the rule of law is a feature in a number of judgments that Lord Neuberger has handed down over the years. You all know Lord Neuberger, of course, as a sitting arbitrator from one Essex court. Lord Neuberger does have a hearing today, so after the keynote he will have to leave. But ladies and gentlemen, can I ask you all to thank Lord Neuberger for coming? It's my pleasure to introduce him to give our keynote.
I should say that the crutch is merely for show and for getting seats on the underground. It's I had a minor operation and my physio says I had to carry it when I'm out of the house, so I do what I'm told. The rule of the physio, not the rule of law. International arbitration, I suppose, can be seen as having 3 principal strands: arbitration between states, arbitration between commercial entities, and arbitration between commercial entities and states. Let me start with interstate arbitration. The notion that arbitration can play an important part in disputes between states isn't new. What's perhaps the foundational work on modern international law, the 1625 work by Hugo Grotius on the War of Law and Peace, he cites the 5th century BC historian of the Peloponnesian Wars, Thucydides, stating that it is not lawful to proceed against one who offers arbitration just as against the wrongdoer, which pretty clearly suggests that 2.5 millennia ago, the famously quarrelsome Greek city-states did not always resolve their disputes by wars, but often submitted their disputes to arbitration. Moving forward 1,500 years, there's also reference to a 12th century treaty between the kings of Castile and Navarre, under which they agreed to refer any disputes to King Henry II of England. As the King of England was the uncle of one and the nephew of the other, one would have thought that these days he would have been conflicted and therefore disqualified. Or maybe he gave full disclosure, or maybe the parties thought that the conflicts would cancel each other out. The idea of arbitration was taken up by the United States and Great Britain in 1794 when they entered into the Jay Treaty, which established commissions to settle outstanding disputes between the two countries following the US War of Independence. Over the next decade, the commissions issued over 500 awards, a number of which identified the precise location of the US-Canada boundary, which of course still remains in place today. And 3/4 of a century later, in 1872, the same countries agreed to arbitrate a claim by the US that Britain had violated its duty of neutrality by building ships for the Confederacy during the Civil War. This resulted in a $15 million award, quite a substantial sum for 150 years ago, which the British paid. 3 years later, the Russian Tsar, Alexander II, acted as sole arbitrator in a dispute between Peru and Japan, arising from the Japanese courts impounding a Peruvian ship carrying Chinese slaves. I cannot see any states today, other than perhaps Belarus, agreeing to an arbitration with Mr. Putin as the sole arbitrator. Around this time, there were many who supported the setting up of a permanent international arbitration court to avoid the effort of setting up ad hoc tribunals who would then also have the problem of being unclear as to the applicable law. This led to the formation of the Permanent Court of Arbitration under the 1899 Convention. One of its early cases was the 1906 Dogger Bank case, which arose from the Russian fleet on its trip 3/4 away round the globe, only to be destroyed by the Japanese. On its way, it attacked the British fishing fleet in the North Sea in the mistaken belief that they were Chinese torpedo boats. The Russian defense of mistake was rejected on the facts. But the PCA was more of a facilitating body, not a permanent court of judges. A permanent court was set up in the 1919 peace conference, but it foundered on the onset of World War II. Of course, following the setting up of the United Nations, the International Court of Justice, ICJ, was founded with its 14 judges. It's not perfect because its jurisdiction is limited to actions by and against states, and states can elect whether or not to submit to its jurisdiction. Of course, its decisions can be overruled by the permanent members of the UN Security Council. But much more important for the global commerce is the World Trade Organization settlement body, which decides more interstate disputes than any other tribunal. In what seems to be an increasingly fractured international scene, the prospects of more universal or global arbitration rules, arbitration laws, and arbitration tribunals between states appears dim. But let's hope that that rather gloomy prognostication turns out to be pessimistic. Turning to arbitrations between commercial entities, as late Lord Mustall pointed out, all trade potentially involves disputes, and successful trade must have a means of dispute resolution. And therefore some form of arbitration-type resolution has existed for thousands of years. Although arbitration was being used to resolve commercial disputes in Britain, it was pretty defective by modern standards until the 19th century. Either party could revoke its commitment to arbitrate, neither party could stop the other party litigating, and awards were hard to enforce. As the Industrial Revolution gathered pace, the detrimental effect of these effects on trade led to a series of statutes which got rid of these problems. But by the mid-19th century, arbitration law, when it came to commercial disputes in the UK, was reasonably coherent. But until the First World War, commercial arbitration was a pretty domestic affair. The growth in international trade and the economic and political benefits of encouraging more growth in international trade was reflected by the formation of the ICC in 1919, with its aim of serving world business by promoting trade and investment, open markets for goods and services, and the creation of the Court of Arbitration 4 years later, which we are, of course, celebrating today. Other institutions followed, including trade associations developing standard forms of arbitration agreement for parties contracting in a particular trade or business, and arbitration institutions such as the London Court, the HKIAC, the SIAC, and specialist organisations such as WIPO. So far as the substantive law of commercial arbitration is concerned, writing in 1988, Lord Mustall referred to the recent flurries of legislation in various countries, resulting in statutes which he said seemed to have practically nothing in common. Since then, many countries, including the UK, have enacted further arbitration legislation. And while there are obviously significant differences between different countries, there's been a general and beneficial tendency to converge and learn from each other. In the UK, we had, of course, the 1996 Arbitration Act, which introduced a new coherent modern structure aimed at reflecting modern best practice. And now, 27 years on, the Law Commission of England and Wales is currently proposing some relatively small and generally sensible amendments to that Act, reflecting developments and problems which have occurred over the past quarter century. And of course, there have been moves to introduce a sort of universal set of rules relating to arbitration. The most successful has been the 1958 New York Convention. With 172 signatories, it represents one of the great attractions of arbitration over litigation, but it still suffers from the fact that some domestic judges, particularly in jurisdictions where the judiciary is not properly independent, can latch on to one of the exceptions to justify refusing enforcement against a resident entity in circumstances where the exception seems clearly inapplicable. Another attempt at universality, which has achieved some success, is the 1985 UNCITRAL model law and its arbitration rules, which are not infrequently invoked. Indeed, the model law founds the basis of some domestic arbitration statutes such as Singapore, Hong Kong, Australia, and Canada. When I embarked on my legal career 50 years ago, arbitration was generally thought to have 6 advantages over litigation: privacy, enforcement, tribunal selection, informality, cost, and speed. Not much has changed in relation to privacy, although I'll have something to say about that, and nothing has changed so far as enforcement and tribunal selection are concerned. But much has altered in relation to informality, cost, and speed. When it comes to informality in the hearings themselves, there's no longer much difference between the courts and arbitral tribunals, at least in my experience. Courts have got a little less formal in terms of courtware and probably more relaxed in the modern age, and tribunals, by contrast, have become perhaps a little more formal. When it comes to practice and procedure, it seems to me that there's been an actual almost reversal of the position 50 years ago. Technicalities are, if anything, more rather than less important when it comes to arbitration. The growth over the past half century in the concern with procedural correctness in arbitrations is in part attributable to the increasing fetter on appeals on points of law. Losing parties, thwarted in their attempts or their ability to appeal on a point of substantive law, cast around to find some ground for arguing that there was a procedural flaw or injustice, and run that point in order to quash the award or at least resist its enforcement. This in turn leads to parties and tribunal members becoming at times positively obsessed with a procedure, the so-called due process paranoia. As to cost, this more elaborate approach to procedure to arbitration inevitably has led to costs increasing. And this has been happening at a time when, at least in most common law jurisdictions, judicial control over legal costs has, in court, meant that litigation may often be cheaper than arbitration. There's been an increased awareness of the duty of judges to ensure that cases do not take up a disproportionate amount of court time, and they have to bear in mind the cost to the public purse and the need of other litigants to get to court. There's also the duty, which is now perceived, of ensuring that a losing party only reimburses the other party's reasonable costs, and to stop too much money being spent on litigation. Different judges have different approaches to this, but it is something which was not really around when I was first in practice. Arbitrators get less involved in curbing costs than judges. That's partly because arbitration is a consensual exercise, and if the parties want to proceed in a certain way, it's difficult to justify the arbitrators objecting. It's partly because arbitrators don't have the public duties of judges. But also, some may think, arbitrators don't want to upset the parties' lawyers because they'd like fresh appointments. Many of the points I've made about cost and procedure apply to the third factor, expedition. From initiation of the resolution process to a final tribunal decision, I doubt there is now that much difference between a trial judge and an arbitration panel. Litigation has become, at any rate some people might say, a bit more efficient, and arbitration has become a bit more procedurally hidebound. But at least, if you are after finality, arbitration has the advantage of no appeals or very limited appeals on substantive legal issues, although you may not think that is an advantage if you are at the losing end of an award which has got the law wrong. Having discussed international commercial arbitration, let me turn to arbitrations between state and non-state parties. The past 45 years has seen the development and growth of investor-state disputes, ISDS arbitrations, many under the auspices of ICSID, arising out of bilateral investment treaties. Knowing that the rule of law is in force and that there is access to effective tribunals to enforce rights when your rights have been infringed by a state, to identify and compensate for wrongs, encourages investment, and so many countries enter into BITs in order to stimulate inward investment. Interestingly, because of the relatively public nature of the exercise, ICSID is now publishing awards. Provided it does not undermine the attraction of arbitration, I would strongly support publication of awards as being consistent with the rule of law for two reasons. First, as any law student knows, open justice is a fundamental requirement of any court system. Secret judgments are not good news. And as arbitration becomes more and more significant on the public stage, the argument for openness becomes stronger and stronger. But I accept one has to balance the interest of the parties and the attraction of arbitration when one argues for increasing publicity for awards. But there's a second reason, which is a more subtle reason. Particularly in a common law system, many aspects of the law develop by reference to case law. And as more and more commercial cases are arbitrated rather than litigated, there is a danger of commercial law ossifying because judges are unable to develop the law, which is particularly serious at a time of great change which we are undergoing in terms of technology, commercial practice and social life. And the danger is that the law ossifies unless arbitral awards are made public, or at least the reasoning in the awards is made public. There have been some rule of law concerns expressed about ISDS awards. An ICSID tribunal can consider the actions of all arms of the state, so that a tribunal has power to consider and condemn what it considers to be an unjustifiable decision of a domestic court, even a Supreme Court decision, if they have resulted in unjustified loss, as the tribunal sees it, to a foreign investor. Although tribunals overruling Supreme Courts may appear unsettling to some people, particularly former members of Supreme Courts, I would suggest that it's an inevitable consequence of an international justice or tribunal system. It's appropriate, I think, to mention the EU Court of Justice's decision in the Acmea case in 2018, which basically held that BITs entered into between EU member states were unlawful because they could result in arbitral tribunals ruling on EU law issues without the Court of Justice being able to consider the point. In my view, the only good aspect of this decision is that it provides some consolation to those who regret Brexit, as it shows there are some benefits to the UK in having ceased to be within the EU. But let me turn now to address more directly a vital point, which I've occasionally touched on so far, namely that it is a fundamental aspect of the rule of law that disputes can be resolved by referring them to an impartial tribunal whose decision will be reached by reference to established principles and will then be respected and enforced. Indeed, this encapsulates one of the most important features of the rule of law, namely access to justice. Although you hear it talked about in relation to individuals and small claims, where it is obviously vital, it's equally vital, both in terms of the rule of law and indeed a successful economy for commercial organizations. Although what I've just said is a pretty fundamental statement and may seem positively trite when pronounced among a group of dispute resolving lawyers, it's always worth reminding ourselves of the fact that our work in international dispute resolution is not only important for the parties involved in the particular dispute, it also has wider importance for the rule of law. That reminder is not to tell you all how wonderful you are, but it's to help ensure that you remember how important it is that we all maintain high standards in our work. And it's worth an observation which is worth unpicking in a number of ways. Why do we need access to justice? Well, if disputes aren't resolved through competent, effective tribunals, nobody knows where they are in their private lives, in their commercial dealings, or in their relationship with the state. Even when there are clear laws, if no one is able to enforce them through an effective tribunal system, the laws have no value. It makes a mockery of the law. The strong, the violent, and the dishonest will prevail against the weak, the reasonable, and the honourable. Domestically, family, social, and work life would fall apart, and businesses would not invest or expand. And internationally, wars would be more likely, and cross-border trade would wither. Secondly, what does access to justice involve? I suggest it's got 5 components: laws which are clear, accessible, and respected; a tribunal system, whether an arbitration or a tribunal or a court, which is effective and respected; tribunals which are impartial, honest, expert, and respected; lawyers who are independent, expert, and respected to advise and to act; and fifthly, a reliable and respected system for enforcing tribunal systems. You will note that in each of those 5 categories, laws, system, tribunals, lawyers, and enforcement, in relation to each of those, I included the word respected. This reflects the fact that the rule of law not merely requires justice to be done, it requires justice to be seen to be done. It's no good having a good system if people don't trust it. So when we as dispute resolution lawyers are advising or representing clients, or when as tribunal members we're deciding, issuing decisions or conducting hearings, we should always bear in mind the lay party's perspective. In this connection, there is a substantial body of research which supports the notion that parties' views as to the procedural justice meted out by a tribunal has a profound effect on their respect for and confidence in the ultimate decision of the tribunal. Thirdly, connected with this, there is the relationship between domestic courts and arbitration tribunals. The very existence of arbitration can be said to be attributable to a degree of distrust of at least some courts. If personal litigants had faith in courts, why would they want to arbitrate? To an extent, this is a fair point. Some countries have a court system whose integrity is tainted. Other countries have some judges, at least, whom the parties do not want to risk trying their cases. And in the international transaction world, neither party may be prepared to trust the domestic courts of the other party. But there are, of course, many other reasons for preferring arbitration: increased party autonomy, confidentiality, and enforceability of awards, thanks to the New York Convention. But far from having a competitive or mutually antagonistic relationship, arbitrators and judges have, at least mostly, a friendly and supportive relationship. Thus, as the UK Supreme Court expressly recognised in a case decided a couple of weeks ago, the English judiciary, and I quote, like many other legal systems, adopts a pro-arbitration approach. This includes, they said, favouring a liberal interpretation of an arbitration agreement in order to respect the autonomy of the parties in determining how their disputes are to be resolved. This is not only due to respect for the parties, the court's respect for party autonomy. It's also very convenient for an overburdened court system to be relieved of a number of cases which are potentially demanding and will take up time. As for the relationship the other way, it can be said that the whole arbitration system is ultimately dependent on the courts, and therefore on access to justice and the rule of law within the court system. Without an effective court system to enforce their procedural directions and their awards, arbitrators would be toothless. In other words, the success of arbitration not only contributes to, but is dependent on the rule of law, and is therefore sensible for arbitration to return the compliment and to do its not insignificant best to uphold and further the rule of law. In adopting a pro-arbitration approach, the UK and other domestic courts are following the legislatures, which in virtually every country of significance have enacted legislation which heavily restricts or prohibits appeals on findings of fact or law made by arbitral tribunals, thereby imposing on arbitration lawyers and on arbitrators a particularly heavy responsibility, as any substantive error by a tribunal is unlikely to be put right on appeal to a judge. To that extent, the responsibility of arbitrators can be said to be greater than that of domestic judges, whose decisions, whichever jurisdiction they sit in, are almost always much more easily appealable. Of course, the courts still have an important role in correcting procedural injustices, but that is a pretty limited function. It's not, of course, just the legal profession, the arbitrators, the courts and the legislators who have a part to play in ensuring that arbitration is conducted in accordance with the rule of law and retains public confidence. The institutions play an increasingly significant role, and they recognise their duty in this connection. Thus, the very first point of the ICC Centenary Declaration is a statement that it is committed to ensure access to justice and the rule of law by providing accessible, affordable, predictable and efficient dispute prevention and resolution services to everyone, every day and everywhere. And other institutions such as the Permanent Court of Arbitration, WIPO, the LCIA, the HKIAC, the SIAC adhere to similar and laudable and principled functions. And I'm pretty clear that they look to what the other is doing and learn from it, which is excellent. A final feature of the rule of law when it comes to international arbitration is the increasing awareness of the need for greater diversity in arbitration tribunals. The need for fairness when it comes to selecting members of tribunals who are to mete out justice is self-evident. Also, it's mathematically obvious that the wider the pool, the greater the potential quality of the tribunal selected from the pool. And more diverse tribunals, provided they are competent, will engender greater public and party confidence. I'm not convinced that diversity on the tribunal will of itself affect the actual outcome, but I accept that it may do so. The rule of law is close to the heart of any lawyer, and perhaps particularly any judge or arbitrator. It's all the closer in my case as I have the honour of being the president of the British Institute of International and Comparative Law, which unsurprisingly has carried out much work on arbitration topics, for instance, the effectiveness of ISDS arbitrations, and it runs seminars on arbitration topics, such as the impact of sanctions on arbitrations under the 1996 Act. I chaired a seminar yesterday at the British Institute involving 3 Ukrainian lawyers who've left Ukraine and come here, and the experience underlined the importance of the rule of law and reminded me, and I think everyone else, how we have to be very careful about taking it for granted in a country which we are relatively blessed by not being subject to the sort of activity which the Ukrainians are having to undergo. As this is the ICC Centenary Conference, and I'm talking about the rule of law, perhaps I could end by identifying 1 or 2 projects which the arbitral institutions could consider, and I suspect probably are considering, to help further the rule of law. With a view to making arbitration more efficient, they could offer guidance to judiciaries to encourage consistent arbitration-friendly approaches when it comes to challenges to and enforcement of awards. It's one thing for the courts to say they're supporting arbitration, but sometimes they may need a bit of education about what goes down well and what doesn't. Secondly, they could consider toughening, the institutions could consider toughening their rules to enable arbitrators to be more robust and less concerned about due process. If parties have agreed to abide by the ICC rules, so to say, then if those rules entitle the arbitrators to do things which otherwise they might not be entitled to do, the parties have agreed that they can do that. The institutions could also take steps to encourage courts in countries with backlogs of cases to refer, or at least to encourage parties to refer, cases to arbitration, which would also involve building up a cadre of expert and respected arbitrators in those countries. Finally, the institutions could perhaps play a more proactive part in encouraging diversity. Before I end, I should like to express my thanks to Lindsay Reimschussel and Denise Guzel for their considerable help in preparing this talk, and to my thanks to you for listening to me. Thank you.